So I thought I'd start with this bipartisan panel of witnesses, just with yes/no questions. Quick, we know this is a complex area of law, and we all want to get it right. Do you agree that it's important for Congress to update the Electoral Count Act to ensure the will of the voters prevails in presidential elections, whatever that will may be? Mr. Bauer, just yes,
Absolutely.
no.
Yes.
Okay, Mr. Gore?
Yes.
Mr. Eisen?
Yes.
Mr. Mueller?
Yes.
Thank you. And then last up, Ms. Nelson.
Yes.
Okay. Do you agree that under existing law, the vice president has no authority to decide which electoral votes to count? And do you support efforts to update the law to make it crystal clear that the vice president has no authority to accept or reject electoral votes? Mr. Bauer?
Yes.
Gore?
Yes.
Eisen?
Agree.
Okay. Mueller?
Yes.
And then Ms. Nelson?
Yes.
Okay, last, under existing law, it only takes one representative and one senator to force each chamber to debate and vote on an objection to a state's electoral votes. Do you support raising the threshold for these objections to require, suggested in this bill, the 1/5 of each chamber to sign an objection before it can be debated as suggested in the bipartisan bill? Mr. Bauer?
Yes.
Gore?
Yes.
Eisen?
Yes.
Mueller?
Yes.
And Ms. Nelson?
Yes.
Okay. That's a first. All right, good. So I just thought it was really important as we look at even some of our questions will be about details that we agree that on the main parts of this bill, there is agreement and we can always make improvements, and I'm sure there'll be discussions about that. One area that's received a lot of attention is the role of the federal courts in ensuring state officials comply with their federal duty to certify electors who reflect the outcome of the election. Mr. Eisen, briefly, you've expressed some concern on the judicial review procedures and the timing of them, that there has to be enough timing to resolve the disputes before the Electoral College meets. Can you talk about that very briefly and what you think would be helpful?
In the 6-day window, you've got to get through briefing, argument, decision, appeal, first with the 3-court panel, then with the Supreme Court. All of this is happening in the context of possible state ongoing proceedings, and it will put a burden on the governors, the AGs, and the secretaries of state who are engaged. It simply is not workable to do it in 6 days. I recognize that on the one hand, the states are going to be pushing for more time, and on the other hand, the parliamentarians and all of you and those in the House who must handle this are going to want pushing in the opposite direction for enough time to get ready. Okay. But I think getting it right up
Getting
front.
the time right. That seems like something. Okay, Mr. Bauer, you want to respond to that?
Yes, I don't share the acuteness of Norm's expressed concern on this point. I think, first of all, it is very likely that lawsuits to challenge, if you will, questionable certifications are likely to arise well before that 6-day period. I don't think it's going to occur right at the beginning of the 6-day period. Also, I think it has been clear over time that courts have the mechanism and recognize the duty to expedite as necessary the resolution of these claims. And thirdly, I do want to stress again that under the Electoral Count Reform Act, we're talking about claims that are very narrowly drawn, brought by presidential and vice presidential candidates to address the apparent submission or refusal to provide a certificate in accordance with state laws. And I think that, again, that will focus the court's attention and enable these matters to be addressed expeditiously, even within a 6-day period. If, in fact, it would help the passage of the bill to add a few days, and it was possible to accommodate those additional times without pressure on the other end as Congress prepares for the joint session.
Exactly.
Well, of course, that should certainly be considered.
Okay. Widespread concern about a provision in the current law, that would allow state legislatures to declare a failed election, appoint their own electors. Mr. Bauer, can you, which would be appointing their own electors but ignoring the votes in their states. Mr. Bauer, quickly explain how the bipartisan bill solves this problem.
It solves this problem, in my view, very effectively by providing that states may, pursuant to laws in effect before Election Day, determine that extraordinary and catastrophic events have occurred that necessitate a modification in the period of voting. And that's key. The remedy here is a modification in the period of voting. It does not allow the states to use the excuse, and that's what was most of the concern about the failed election provision under the current ECA, to redo the election, to throw the old one out and conduct another one. So I think that it very effectively addresses the concerns that we have over legitimate problems that may arise with cyber attacks, power outages, natural disasters, while at the same time preserving this fundamental principle that laws, that due process requires us to honor the results of elections that reflect the popular vote under the rules in effect on Election Day.
Okay, Ambassador, you've expressed some concern that the language in the bipartisan bills allowing states to extend Election Day during an extraordinary and catastrophic emergency is vague. I mean, I'm glad that they had an exception and something we had in our bill, Senator King, and presented for these catastrophes. You can have weather catastrophes, right? So do you have anything you can suggest then that you think could make this more defined?
Chairwoman, if this committee were solely in charge of administering extraordinary and catastrophic, the anxiety that many of us feel in looking at the election denier landscape and the brazenness and the willingness to go to the very limits, that alarm would not occur. But I think, given that Congress has defined this term, extraordinary and catastrophic, you can put some guardrails around that to prevent the bizarre idea, which can be done before Election Day by an election-denying governor, particularly if there's a trifecta, if they have both houses.
Okay, but if you could just be any specific language, you can give it to the committee later.
The guardrails can be force majeure. That would be a good one.
Okay, I have one last question. Ms. Nelson, you testified that reforming the Electoral Count Act is only one step in protecting our democracy. I know you'd like to see some changes. We can go over those later. But could you speak to why additional legislation like the Freedom to Vote Act and John Lewis bill would complement the work that we've done here? Ms. Nelson.
Yes, because election sabotage happens not just after ballots are cast and votes are manipulated. It can happen in the way that the electorate is shaped through voter suppression laws and through laws that erect barriers to the ballot. And so the John R. Lewis Voting Rights Advancement Act, restoring and strengthening core protections against voting discrimination that we lost in the Voting Rights Act of 1965 when the Supreme Court struck down the provision and disabled it. We also need the Freedom to Vote Act to set minimum standards for access to the polls so that voters in Florida and Georgia and Texas can benefit from same-day voter registration, for example, or robust vote by mail and ballot return procedures, just like voters in California and Colorado and other states. The uniformity of those voting measures will restore and bring greater confidence to our electoral system and will complement the work of the ECRA.
Thank you very much.